Hi, everyone. We're going to wait just a few seconds so that everybody can log in. Okay, let's get started. Hi, everyone. I am Annette Pinyazic. I'm the HAPS Director of Grants and Major Gifts. Thank you all so much for joining us. This is HAPS Estate Planning Education Webinar, and we launched this series in response to requests from our community members about estate planning. And our presenter for this series is Kathleen Wiesenthal. She's an attorney with Keever and Wiesenthal, and her practice focuses on probate, real estate, and estate planning. And today she's going to talk about life-proofing estate plans by avoiding common mistakes. And we have reserved some time for questions and answers after Kathleen's presentation. You can add your questions for Kathleen at any time to the Q&A at the bottom of your screen, and we will answer them all at the end after Kathleen is finished. And today's webinar is being recorded, and a link for it will be available on the HAPS.org website and also on the HAPS YouTube channel. It'll probably take about a week before that will be up. So thank you guys, and I am going to turn this all over to Kathleen.
Great. Thank you all very much. It's very good to be back again. And I really wanted to do a lighthearted view of estate planning because it's so very serious most of the time, and it was time to do something a little fun. We're in the middle of um, uh, Halloween season, and we're getting ready to talk about scary things that can happen to you. And so I'm going to tell you a little bit of real life stories and kind of give you an idea of what can go wrong when you're not anticipating something that could go wrong. When you usually come in to do an estate plan, you have, at that time, your life is probably pretty even. And all the relationships that you are involved in are probably pretty stable. Even if they're bad relationships, they may be stable though. And you don't think about what will happen if, because other people have a huge effect on your estate plan. My job as an estate planning attorney is to make sure that my clients have a plan that suits them and them alone very, very carefully. However, you can't ignore the family dynamics, and you can't ignore those things that will happen that will mess up your plan completely, and you'll already be gone and nobody will be able to help on this. So we are going to get in our first section. We're going to hold on, I'm going to move my camera over a little bit here. There you go. In our first sections, we're going to cover obviously, wills, powers of attorney, transfer on death deeds, and reviewing your payable on death designations. As an estate planning attorney, I really encourage everybody to get a will because it is the easiest way for you to be able to tell your family what your wishes are for the assets that you hold, and to make sure that when that will is probated, those assets are legally transferred to the people that you want them to go to. The powers of attorney are the documents that will help while you're alive and perhaps incapacitated. Don't necessarily have to be incapacitated, but powers of attorney are the documents that you will prepare and give someone else control over your life and your finances, your legal matters, your person, when you're talking about medical powers of attorney. All of these things are very important documents you don't want to take lightly. Transfer on death deeds or something else that can help eliminate some of the drama that goes with a will. For instance, with your biggest asset, your real property, transfer on death deeds have the ability to be able to move your property in writing to the persons you want to have your real property, which is your real estate and your improvements that are located on that real property. And if you just have land somewhere, that will also be transferred by a transfer on death deed if you choose to do so. But it's property specific though. So if you don't plan on living in this home for the rest of your life, or you think you'll probably sell it at some point, maybe a transfer on death deed isn't for you and you stick with the will. And that way we can use a little bit vaguer language. It's a little more vague, and to convey any real property that you have at that time. And then reviewing payable on death designations, which we'll go over in a few minutes. So, first of all, I wanted to talk. There's a lot of trust involved in preparing an estate plan. And one of the things you might want to do is most people will say, I want my spouse to be my executor, or I want my oldest son or oldest daughter to be my executor. But you need to be aware that any persons with felony convictions could be disqualified from serving as your executor. If your designated executor is your only beneficiary, their past may be disregarded by a court because they can be the executor of your estate if they're the only person who is going to be uh, partaking of the assets in the estate. If there's anybody else who's a beneficiary in your estate, that felonious executor will not be able to serve. And you probably should know that up front or make allowances for that up front and designate somebody else to be an executor. If you have other people that are going to be your beneficiaries, I would greatly encourage you to pick somebody besides that person, besides the felonious executor, and have some backups too, in case you have other people. And if you don't have any other people, then we can talk, you and your attorney would talk about that. And there's other options and to move around that. But it's very, very important that the person that you designate as an executor is going to do their job and that they have the wherewithal to do the job. It is not an it's not a complicated job, but it requires some organization skills and it requires a little bit of financial savvy. So if when you're going to pick an executor or a trustee, kind of pick whichever child is the best one. Or if your spouse is not exactly good at financial, uh, that if any financial issues or legal issues, things like that, that could be very scary. So there's another really spooky part of that. So you don't want people taking control of your estate just because you love them, and you need to pick somebody who's going to be very helpful in that endeavor. All right, let's talk about the predators to your estate plan. I mean, this guy's pretty scary, but having anybody who is a predator to your assets is even scarier. And it's really, really difficult for your family to deal with somebody like that. And it will end up costing your estate a lot of money. I can't even begin to tell you how expensive it could be if you have anybody that is going to give you a hard time. So if you need to disinherit someone, not an easy decision. It's never made lightly, but it is something that you really need to discuss with your family and to make sure that you've got the language in your will that prepares a court and gives them the court or a jury for that matter, gives them the tools they need to explain to that person who's trying to get back into the will and thinks that they were done poorly. Um, you don't disinherit somebody just by omitting them. You must put language into a will that says, I disinherit Johnny, and he's familiar with the reasons. Uh, Another common language is, I disinherit Johnny because he has already been given a large sum of his inheritance by me during my lifetime. Um, I disinherit Sally because she has um, a, a problem with not being able to keep money or something like that. You don't want to get too personal in a will, obviously, and you don't want to hurt anybody's feelings. I can always come up with language that can make it a little bit smoother. However, if you have somebody that you feel like is going to be a spendthrift and will just spend everything they get, and you kind of like to make sure they wouldn't do that, one of the less scary options is to perhaps put that person, his assets, his or her assets, into a trust. That can be done right within your will. It doesn't have to be fancy. It doesn't have to be a separate document. It can be part of your will. And you would say that Johnny and Robert will get their inheritance directly, but Evelyn will get hers in a trust, and her trustee will be X. Please don't make it a sibling. Usually, that's a pretty bad idea too. And that she will get her money, $3,000 a month for the rest of her life, or when the money runs out. That's one way to ensure that you still give something to your loved ones without completely disinheriting them. And and you can skip a generation in that kind of an arrangement. So if you've got scary kids, I keep using the word scary because I'm trying to be Halloween, um, uh, trying to keep in the spirit of Halloween here. If you've got kids that are a little bit scary and you just don't want them to have any of your assets, but you love your grandchildren, you can disinherit your child without disinheriting their children. And so you want to check into something like that with your attorney when you're doing a probate plan, and make sure that you've got the ability to um, pick who's going to get your assets. You get to decide that. It doesn't necessarily have to go to your children. There is no law that says it has to go to your children. You get to pick whoever your beneficiaries are going to be. Um, if you want everything to go to a charity, you can decide that. You are not bound by any type of a law to decide who your beneficiaries are going to be. But I want you to feel comfortable with knowing that you have options too. And that sometimes can free up your plan a little bit more and give you the ability to be more creative or to skip a generation. And so just keep that in mind, that you're not bound to leave everything to your children if you do not wish to. Disaster preparedness. What if I have a lot of people come to me and say, I want to ensure that my homestead goes effortlessly to my beneficiaries. And basically, what they're also saying is, I want to avoid probate. Those are two separate things, but that is often what people mean when they say, I want it to go to my beneficiaries with no problem. There are ways to arrange for your homestead to go to your children, such as the transfer on death deed. That's a deed that is allowed by the Texas legislature. It's rather new, it's within the last 10 years. And you are allowed to put on file a deed giving your current property to whoever you wish, and upon your death, that deed takes effect. In the meantime, you lose no rights in your property, you lose no interest in your property, and your beneficiary cannot claim any interest in that property while you are still alive. They can't be, creditors can't attach that for them to be penalized, and maybe putting something on the property, you are still the owner of that property. You're still responsible for the bills and the taxes. But when you pass away, that property, because of that deed, will automatically pass to your beneficiary or beneficiaries. Um, that's one way to make sure that your homestead goes effortlessly to your beneficiaries. It's an extra step that you can do if you've maybe got conflict in your family. Again, scary family. And if you don't have that kind of conflict, it's not something you necessarily need to think about. It's just an added step, and there are a lot of factors not to do it too. Um, but the idea is that you want to be able to make sure that you direct your property very narrowly to the people that you want to have it. Um, Now, taking care of your homestead, aside from everything else in your estate, a lot of people think that will keep them out of probate, their will out of probate. Not necessarily, because you really need to sit down and consider the other assets that your executor is going to have to deal with. Do you have checking accounts? Have all the checking accounts or accounts held by financial institutions? Have you taken care of updating your beneficiaries, making sure that your beneficiaries are clearly stated, and making sure that the custodians of your financial accounts, brokerage accounts, financial accounts, bank accounts, CDs, things like that, you're responsible for making sure that all of those beneficiaries are updated. Those beneficiaries, if they are not on those assets, will be governed by the will. So if you leave um, all your CDs to Robert, but you've disinherited him in the will, Robert still gets those CDs. He's just not going to get anything else that passes through your estate. Think of the estate as a basket. Anything that isn't already taken care of with a custodian for a financial institution will go into a basket. Assets that are already with a custodian of some sort, usually we're talking about checking accounts, CDs, brokerage accounts, things like that. If you already have beneficiaries set up, those documents that you have with that custodian are a contract which rules what happens to those assets. Your will cannot supersede what you already have done with the financial institution. So therefore, if you've left Robert, like we talked about just a second ago, if Robert is getting all of your CDs, he's the beneficiary. And in your will, let's go to the extreme and say you disinherited Robert. If you don't change the beneficiaries on those CDs, Robert will get those directly from the bank. Those assets will never fall into the basket that is your estate. So if you have designated your daughter to be the beneficiary of all of your bank accounts, and your daughter unfortunately has passed away before you did, then if you don't designate another beneficiary, that will become a part of your estate. So those assets will be payable to your estate, and then your executor is going to have to disperse those the way that your will has asked to. So, for instance, you may say, I want all of my worldly possessions to go to my spouse. If my spouse doesn't survive me, then I want it to go to all of my descendants per stirpes. So, if that's the case, if the checking account didn't have a beneficiary, it will go into your estate, and then it will be split between all of your descendants if your spouse doesn't survive you. If your spouse survives you, then your spouse will get those assets. But those are the things that an attorney should be explaining to you as you go through your individual assets. And those are the opportunities for you to really think it through to make sure that you've got your homework, to keep following up with brokerage accounts and accounts. I always suggest to my um, clients that you check those every couple of years. With banks, I'd look at them every couple of years, especially if the bank gets bought out by somebody else. If it's a brokerage house, look at those statements. Make sure that the beneficiaries are still listed on those statements and that they are accurate. And if it's like a 401k IRA, usually if you have a spouse, if you want those to go to anybody but your spouse, the spouse has to sign off on that, unless your spouse has predeceased you. So those are just things to keep in mind as you're going through and fashioning your beneficiaries with all of the financial institutions. I have a question up here. The third question: does the ghost of a co-owner still haunt your title? Now, here's something that can really, really mess people up. I want to tell you a story about somebody. I had a client who came in to see me after her husband passed away. She wanted to sell the house, so and he had not done a will, and so we had to do determine the heirship of her husband, which means just finding out who his descendants were, who's entitled to his property, etc. Um, she had 3 children with this gentleman. He had 2 other children by another relationship. When you don't have a will, the property will, his share of any community property is going to go directly to his children. The spouse gets to keep their half if they had a half. And the only way that a spouse can share 50% in a community property state is that anything that you purchase from the day you got married to the day you get divorced or die is considered community property. It's presumed community property unless something is brought out of the woodwork to prove that it belongs to one spouse or another. She purchased this house with her husband, she thought. He had at some point frozen the taxes. Therefore, they weren't paying any taxes for close to 15 years. Now, I don't know if you know this, but when you freeze your taxes to save yourself some money after a certain age, when you pass on that property to someone else, all of the taxes become due. So, for instance, the house they lived in, she would have gotten the property at some point. Actually, well, she got to keep her half, but even on her half, he froze the taxes so that when she goes to sell this property with his children, because there's children on the other half, they are going to have to bring up to date and pay all 15 years worth of taxes they didn't pay. Not necessarily with interest. It depends what you work out with the appraisal district, but you are going to end up paying a large portion of what had not been paid all those years. People don't realize that, so that's something you have to go into very carefully. In the meantime, though, her situation got even more messed up because he had one of his daughters, not by her, the other daughter, forge her name on a deed, giving the house to his half of the house to his children. And so he didn't any longer own that. His children did, and she owned the other half. And so she's on the hook, besides only owning half of that house, obviously. She uh, is on the hook for 15 years worth of taxes. It's not a situation that you want to be in. I have another client who are divorced. She's divorced. Thank God she's friends with her ex-husband, but he was supposed to have signed over all of his interest at their divorce according to the divorce decree. and his attorney never prepared that or filed it. And so she still owns half that property with her ex. Thank God, in this particular case, he's amenable to signing whatever he has to sign to give her 100% of the house. But sometimes that isn't always possible, especially if you have a co-owner who passes away and you're going to prepare your estate plan and you find out you only own half of your house and you have to go and get in touch with the other person's estate and things like that. You want to make sure that your paper trail on your property and any other assets, not always just your home, but the home is the biggest asset. You want to make sure there's no ghosts haunting your title on your house. That is not an enviable position, and it leaves people almost destitute. I mean, the wife that her husband had not paid the taxes, she ended up with zero when it was all over with. She had to sell the house to pay the taxes and had nothing to go buy another house with. Not a situation you want to be in. I would suggest to any spouse who has no idea what their financial situation is that perhaps you have a sit down with your spouse or have an attorney help you figure out where your title for your property lies. um, let's not have any ghosts in your house or on your assets. If it's possible to cure those things before you pass away or before your significant others or ex significant others pass away, that's a disaster preparedness that is extremely important. It messes up a lot of probates because a lot of people are not aware of what went on and what their if their spouse did all the finances. It's an awful, awful situation. So if you're out there listening and you don't do the finances with your spouse, I suggest you sit down with them and go through this very, very carefully and make sure that you're aware of exactly what's going on, whether or not your taxes are frozen. Now, if you've got an over 65 exemption, that's different. That is not something that has to be paid back. But freezing your taxes is an option for people who are in desperate situations and that they're not as concerned with the money being pulled back by the estate, pulled back by the government or the appraisal district after a death. So it is confusing. If you have any questions about it, contact your attorney and make sure that your ducks are in a row and that you've got everything prepared for a disaster. Just pretend there's a hurricane coming and you have to get this all prepared. All right. This was not meant to be a subliminal um, uh, having sharks everywhere, talking about your spouse's children. This is very real. I'm here to tell you the scary stories. Obviously, there are beautiful stories about stepchildren who do not act so greedy, do not try to take um, away from a current spouse. But there are some very scary stories out there about stepchildren who feel they have the right to everything and they don't like it when the stepmom, I'm going to use, daddy dies, stepmom is alive. They don't like it when stepmom takes over and has all of the assets. And that's usually, if you think about it, that's what a spouse is going to do when they pass away. Very often, if they have a good relationship with their children, they will leave a certain amount to their spouse or certain accounts, and then the children will receive certain amounts or separate accounts, or maybe they'll divide property up between the children, their children not with that other spouse. The point being that if you've got children by another relationship and you're currently married to your second or third spouse, you have got to be very clear in your will about who's getting your property. And we've got to make sure that that is ironclad in your will. Now, There's this the reason for the sharks is sharks don't care what the law is. Sharks don't care whether or not you're alive or dead. The sharks are going to go after anything that they consider to be theirs. All right. Children who contest a parent's will or even the absence of a will um, are they don't have to have a good reason to contest it. They have to have a good reason to win. Okay. Any child can go and contest it and cause your spouse to have to um, uh, defend themselves by hiring another attorney. And you end up with, $400,000 worth of attorney's fees. That's not an exaggeration, by the way. And you don't have um, really the realistic expectation of receiving any of that back. I just went through an estate that was worth over $2 million, and the attorney's fees were over $500,000. And I don't get the point of that myself. I'd rather have the 500,000 and just take what daddy left me. That was not the way this one worked out. Um, what you want to do is, if you have children of your own and your spouse has children, for instance, do separate wills and very clearly set out and think forward to what you want to have done when you pass. If you have two children and your spouse has two children, in your will, I would put, if you want your children to have something of your estate, but you do want to leave something to your spouse who you've been with for 20 years, but they're the second spouse, you want to make it very clear your children will have X, the spouse will get Y, and a Z could be grandchildren, anybody else that's going to receive anything. If you leave everything to your spouse and think you have an arrangement with that spouse for them to divide everything up between all the children, please don't rely on that. It's not because the other spouse would be bad. They can change their will anytime they want, unless you have a contractual will. You don't you don't want to leave it wide open for somebody else to have to make a gift to your children. If you leave anything to a beneficiary, including your spouse, it's theirs to do what they want with. You can't tell them how they're supposed to give it away when they pass away. They can change their will at any time unless it's contractual. And even then, it's still up to having the lawyers go at it. If you've got a situation where you've got that you're also giving money to your stepchildren, give it to them when you die. Don't wait and make your spouse promise to do that giving after you're gone. A spouse may be in a totally different circumstance. Like I said, they're not bad people, but people become maybe she lives to a ripe old age and needs that money, all of it, for her care and can't afford to leave anything else to anybody but her children who are taking care of her. That kind of a situation. It's not necessarily a bad person, it's just that things change. So when you go to see an attorney about an estate plan, please make sure that you just entertain what the attorney puts in front of you. Think about it. Just go to that apocalyptic shark-filled water and say, okay, what is the best way to make sure my children get my estate and that my spouse isn't going to eat it all up and then give it to her children and my children get nothing? That's the kind of thing that you want to avoid in a lot of cases. There are ways to do that, and the language matters. So the language in the will matters a great deal as to what you're going to call your children. If you define your children as your kids and the stepkids also, then when you say children anywhere else in the will, That's going to mean all of those kids. So if you're going to give something to your children, you need to define that differently. And your stepchildren, you need to define differently. Um, Also, if you find that it's necessary to, um, if you find that it's necessary that somebody else needs to control the money that comes out of your estate so that you don't have the situation where your children will end up with nothing, you can always try to set up a trust. And that trust could last until they're 45 years old or something like that, until your children are adults. Um, Sometimes that's helpful too, so that nobody else can get into that trust or spend that money except your children. They may not get it outright, but they still have it to be able to use those funds to enhance their life, or also just to, oh, there's so many different things that the children can do with the trust money, and it depends again who your trustee is going to be. So there we go again. We're back to trust again. Just the word trusting somebody. All of these things will matter, and your attorney should be concentrating on having those conversations with you if you have a mixed family or a blended family. Now, if you have powers of attorney in place, I know there's a great deal of care that goes into choosing the agents who are going to help you in your old age or even in your incapacity, to help you decide what to do with your finances and um, with your assets, if you have any at the time that you're incapacitated. And so if you have those powers of attorney in place, that's going to help a lot with the ability to control your estate while you're still alive so that nobody else gets a chance to spend it, dissolve it, use it, give it away, things like that. We want to make sure that even if you have children that you are going to put as your powers of attorney, as your agents, you have to make very sure that your children have the ability to do that and that they're able to hold that together while you're still alive before you even pass. The money that you are putting in the care of your agents in a durable power of attorney is not the children's money. It is your money for them to use for your benefit and only for your benefit. So that's something you must keep in mind when you're putting together agents into your power of attorney. Don't just pick anybody because they're available and willing. Okay. Again, that goes back to protecting your assets before you pass to make sure that you haven't given away any powers to control your own assets before you go, and so that you still preserve what you want your children to have. Are your wishes spelled out? A will has very elemental parts to it that are what everybody calls boilerplate. That is part of the process of having a will. You want it to be accepted by third parties. You want the court to accept it and consider it to be valid so the court can enter it into probate and therefore make all of your wishes a legal transfer. If you don't spell out exactly what you want, it could go haywire. A lot of attorneys will go over all of that with you, and they will take the time to say, okay, but what if? And what if? And you have to take that extra step into the apocalypse because sometimes you have to go through a scenario where what if all of your children are gone and all you have left is grandchildren? Do you want to make sure the grandchildren get this? And if so, are they under the age of 18 today? And so we have to set up trusts for them, et cetera, et cetera. There's a lot that goes into thinking for the next couple of generations sometimes. Even if you don't think you have a lot of money to give away, you'd be surprised how things can go awry. You don't want it in the wrong hands, and you don't want it in the hands of somebody who decides to contest your estate and can make a good case for why they should be given some of your assets when you didn't actually leave them any. I like to tell my clients that my plans that I prepare for them are supposed to be evergreen, which means that they will succeed in cementing your plans into place in that will if it's probated. If it's not probated, I can't promise anything. But if you probate that will, all of your plans can be set in stone, so to speak, or at least legalized, so that you have the opportunity to take care of several generations if need be. And again, you always assume what if your kids aren't here when you pass? What if you give everything to 4 kids and one of them passes, and what's going to happen with their share? Does it automatically, do you want it to go to their siblings? Do you want it to go to that decedent's descendants? Or these are all things that you can plan for and arrange for. Do you want that person's share to go to charity, if that's the case? But all of the idea is that your money should never just languish, and it should never be up for debate about what's going to happen to your estate. You want to make sure that the people you love and cherish are going to have the assets you worked so hard for all of your life. Your estate plan, even though there's boilerplate language, is very, very unique. Your powers of attorney, your wills, those are all things that should be crafted around your unique situation. This is not, if this were something that you could just fill out a form like they have online, um, and you could just take that to the court and that's that, there'd be no point in having attorneys doing estate planning. The whole idea is that everybody's individual. You're different from your neighbor, you're different from your brother, you're different from your own children in how you want to take care of your estate plan. You've got to have your estate plan reflect you individually. Even if, again, even if you think you don't have much, doesn't matter, because it's still yours and you still get to decide exactly what happens to it. This video is just to remind you too, don't expect your estate plan to be done by just anybody. Make sure you get a probate attorney preparing this for you. A probate can be a specialty. For instance, I'm not specialized in probate, but that's all I do. I do probate guardianships and estate planning, and I have knowledge in real estate because I used to work for real estate companies for years. So the idea is that I've got the ability to take your estate and predict it all the way through the end when your family receives it to make sure everything is going to go smoothly. Don't let somebody who doesn't know how to fit the square into the square space try to do this for you. You want to make this as easy as possible by going to somebody who has the ability to understand what this is going to look like to you, to your family, what it's going to look like in a probate court, how a judge is going to view it, and if necessary, God forbid, what it's going to look like when you have the issue of any contests to your estate. Nobody wants that, but it does happen. And you want to make sure that your will and documents are put together so well that you don't have to get into that situation. At this point, I don't have any other copy to give you for this presentation, but if you have any questions, I would be very glad to , address those.
Thank you so much, Kathleen. As always, really great information. And just a reminder to everyone that today's recording of today's webinar will be available on the HAPS.org website and also HAPS's YouTube channel. We do have some questions. And again, if you have a question for Kathleen, please feel free to put it in the Q&A box at the bottom of your screen. But we have some questions that have come in. I'm going to start from the very beginning. Is inheritance considered community property if it's inherited after you're married?
No, inheritance is always considered separate property unless you commingle it. So if you receive money, cash money from a family member as an inheritance, and you take it and put it directly into your community estate and pay your bills out of it and pay for, trips out of it and things like that, it is community property then. You have, and I'm kind of encapsulating this in a nutshell. It's not. There are arguments to the contrary, but there's the divorce arguments and then there's the probate arguments. They're both a little different on how they trace assets. But normally, anything that you purchase or acquire during marriage is considered community property. Everything else is separate property. So an inheritance falls into that everything else category. And if you keep it separate, it will continue to be your separate property and you can pass it down to your family as separate property for your children also.
Hey, this is a compound question. I have Parkinson's, but my spouse has dementia, and I'm the primary caregiver for him. Is there anything I can or should do to set up someone for his care or set up something for his care if something happens to me? Does this require some type of official legal document?
Yeah, yes, it can. The question is, it depends. The answer is it depends, and that's kind of a lawyer answer. But if you have people that you know that you can trust your spouse with, if something happens to you and you pass away, your spouse can be taken care of by people that you suggest. Hopefully your spouse already has powers of attorney and has successor powers given to someone, to successor agents designated, so that if something happens to the primary spouse who's taking care of them, they've got some other agents in place. But a lot of times people haven't done that yet, and I understand that. Um, it might require guardianship for your spouse in order for somebody to be able to handle their finances and their bodily medical issues and things like that. That's a very hard question. It would if you were in front of me now, I would ask you lots more questions before I could actually answer that. But hopefully that gives you an idea that it is complicated. You should see someone about it.
Hey, great. So is it more advisable to make my daughter my power of attorney rather than make her a co-owner on my financial accounts? What are the pros and cons of each?
Okay, making somebody making us your child a co-owner on your account is a brilliant idea, and the idea is that you want somebody to be able to take those accounts and be able to use them immediately upon your death rather than the bank freezing them. 90% of the time when a bank finds out someone is deceased, and they find it out immediately once Social Security gets word of it, and that comes from the funeral home, so it all just kind of avalanches down, and the banks will freeze the account if there are no beneficiaries or co-owners. What you want to have, and make sure you do this, is that you have a co-owner who is also a joint tenant with rights of survivorship. So they have immediate access to that money. Sometimes just being a joint tenant is not enough because the bank will freeze it anyway and say, oh, we don't want to decide how much was hers, how much was yours. So we're going to freeze it until you get a court order, okay, when you go through probate. And the downside of having a family member being on your accounts is they have to be sure they're not using that account for their own expenses. You have to have a very clear understanding that that's your money and they're on that account for the ease of making them a beneficiary further down the line. um, don't let your kids start taking money out and then tell you a week later, oh, mom, I took out $500 because I needed it for something. That's a downside because your children feel like it's okay. You're my mom. You're my dad. I can do this. You have to have a very clear understanding with your child before you do that.
Okay. What do we need to know about vehicle titles?
Vehicle titles are actually pretty easy. One thing I always tell my clients is if you want your grandson to have your car when you pass away, sign the title. Sign the title over to him and let that title just sit in your drawer until and tell your daughter or your executor and say, look, I've already signed the title over to Johnny. Go ahead and file it with my signature on it, signing it over to him. It's also very easy. Once you have a will probated, you're able to take a copy of the letters testamentary that you get for being an executor. You can send that to the Department of Public Safety or motor vehicles or whoever it is that changes those, and let them know that in your will, you left that car to Johnny and that they are the beneficiary of that. Um, it can be tricky because you will have some family members. I see it more often than not. Some family members say, well, I took care of mom, so I'm giving the car to Johnny. Well, that might not be what it says in the will. And so you've got to make sure they're not going to go a step ahead of you and go to the Department of Motor Vehicles and say, okay, she's dead, sign it over to me. I was the executor, or something to that effect. That can happen. It's ugly. I mean, I hate it when families do that to each other, but there are ways to put it in your will, make it easier, or like I said, sign over the title before you pass away.
So if someone has signed over the title to someone before they've passed away,
Uh-huh.
is that vehicle, would that gift supersede anything that may be in the will itself?
Yes, it could, because if you've actually signed over a title and then you change your mind and you change it in your will, that's a problem. Yes, that could be a really big problem because that's dual intention. It's going to be very hard for anybody to decide who that vehicle goes to. I use that as an example because sometimes they only have one grandson and they want that grandson to have the car, and everybody kind of knows that they want him to have it, so it's done and done. But if you don't know for sure what you want to have, maybe it's an antique vehicle, it's got some value to it. For gosh sakes, put that in the will. Make sure it's in the will that my 1951 whatever, it gets in to my grandson John. You know, you those are the kinds of things that you have to think ahead a little bit and make sure that you've got those in writing so that they become legally effective because the will was probated. If you put it in a will and never probate your will, remember it's a piece of paper. That's all it is. It's a doorstop. It's a piece of paper. That's all you have. You want it to be legally effective.
Okay, thanks. Some attorneys have suggested placing assets in a revocable trust before you pass in order to avoid probate. Do you agree with that?
Well, that would be wonderful if all of your assets go into that trust, your checking accounts, your artwork, your furniture, your home, your everything. goes into that trust and then gets divided up between your family. That's a great idea. That's wonderful. And then you can avoid probate altogether. However, if anything is not put into that trust, it will be it'll become an intestate asset, and you will have to probate for that asset to pass anyway. Plus, if you pass your home into a revocable trust, you've changed ownership on that home. There are several ramifications for that. One is that your title insurance may be void because you've changed ownership. A trust, if you're giving it to that trust to own that property, you're changing ownership. And then, unless you get a title company to enhance that somehow, you have given that property away and your title insurance will stop. Not the end of the world for most people, but you also have now um, interrupted the capital gains baseline for that property. So if you take your house today and put it into a revocable trust, you have changed ownership on that property and it goes into that trust at the value that you put it into the trust. It also could be argued it only goes in at the value you paid for it at the time you bought the house. So if you've been in that house for 40 years, that's a big difference in appreciation. And then when your children inherit it, they have to pay the capital gains tax between when you put it in the trust and when they sell it later on. So that's something that you also would want to check with your CPA in your particular situation. If you've got a house that only appreciates, $500 a year, don't worry about it. But if you don't want your kids to be hit with a huge capital gains tax, I suggest you talk with someone about that.
Okay, another question. If my daughter is a co-owner of an account, does that count as their income or assets for tax purposes?
That I don't know. I'm not a tax attorney, and I choose not to be one. So it's not my favorite thing because it's very complicated. As far as I know, if somebody is a co-owner of an account, it can come to bite them at some point. For instance, when they turn 65, it will be considered part of their income, trying to determine whether or not they're eligible for Social Security, Medicaid, things like that. It does play a part um, in 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 your own financial uh, oh, what's the word I'm looking for? In your own financial world, it could play a part in that because you have access to that money. Okay. So, but call your CPA. And I don't mean call H&R Block. I mean call your CPA and make sure that they've actually addressed the issue. So,
Okay, if my son is my co-owner on my accounts, but in a crappy marriage likely to end in divorce, can his wife have access to that income in a divorce?
that's a possibility, yes, because they have an ownership interest in that. If you only have them as a signer, um, or maybe a beneficiary only, that's different. But if you have them as a joint tenant, that is a downside of having a family member be a joint tenant. It could be considered part of their income also. Again, divorce is different than probate law. Family law and probate law are slightly different. So in family law, everything's up for grabs. In probate law, it's a little bit more stringent.
Okay, we have another question going back to titles. How do you sign over a title?
You do a deed. Your title in Texas is a warranty deed or a deed without warranty or a special warranty deed. Those are the kinds of documents that are prepared to transfer title to someone. If you want to transfer title to someone, not doing a transfer on death deed, and all you want to do is transfer it to someone like right now and have them take ownership for it right now, that is just done by a deed. It depends on whether or not there is a mortgage on the property. If there's a mortgage, you have to do a deed with vendor's lien, and that vendor's lien will also move over with the property. However, the mortgage might not. So that's a complicated question too. Once again, it's one of those questions that I will probably ask you a lot more than for that one question. But the idea is just a deed. There are several different kinds. Keep that in mind. It isn't just boilerplate. Okay.
I think that this could also apply to vehicles. So if you have a vehicle, and since you were talking about how people could sign over the title to their
Mhm.
vehicle, I
Mhm.
perhaps that question, because it's not stated in here, perhaps that question was referring to that type of title.
Oh, they
How do
could
you?
be. Oh, I
Mhm.
see what you're saying. Yes,
Yeah.
I understand. Um, to turn over title for a vehicle, you just simply sign the back of the title and turn it into the Department of Motor Vehicles or Department of Public Safety. And you just make it clear that you've sold that vehicle, sold or received some consideration or given it or whatever as a gift. But yes, that's all you would have to do.
Okay. How much is the capital gains tax limit before you have to pay taxes on estates?
There is no limit. As far as I know, there isn't any. It could, and again, I'm not a tax attorney at all, not even close. So don't take my word for it on this. Definitely contact your CPA, and if there's a CPA out there, correct me. But as far as I know, on capital gains, there's no limit. On inheritance tax, you don't get, assuming that might be part of what they were asking on inheritance. You today, if you have $14 million you're giving in inheritance, no inheritance tax is necessary. But if you have over 14 million, then it's most likely that you're going to pay an inheritance tax. Capital gain is a little different, and I'm assuming that the person that asked that question understands the difference, but I didn't want other people to be confused about the question.
Okay. Well, thanks. This has taken us to just a few minutes past our time. Again, Kathleen Wiesenthal, thank you so much.
You're welcome.
Kathleen is with Keever and Wiesenthal. And just a reminder to everyone out there that today's recording will be available on the haps.org website and also on our HAPS YouTube channel. And thank you, everybody, for joining us today. We really appreciate your time. Thank you so much.
Thank you, everyone.